Wolf's legal director. Do you want me to hold it, or do you not trust me? Okay. Happy to be here. We are here to talk to you about impact litigation and the legal front in this fight. And one of the things I want to talk about a little bit is Wolf's legal work in various forms, and then also some of the challenges that I have experienced and seen others experience in terms of fighting these fights in court.
Yeah. All right. My name is Elspeth Cypher. You can call me Ellie. I am a retired justice from the Supreme Judicial Court of Massachusetts. Which, just so I get this clear, you know we are the oldest. See, I'm having an identity issue because I'm saying we, and I'm gone now. It's the oldest continuous court of review in the Western Hemisphere, started in 1692 to stop the witch trials in Salem. And so we're very proud of that. And they were very proud also of Goodrich versus Public Health, the gay marriage case in 2003. I've been on the bench in Massachusetts for 23 years. I started, when I was raising my son and life was going on, and I was first in the appeals court and watching stuff. And then the gender stuff starts coming around. But it's Massachusetts, and we were already on board with that and what was going to happen. But in 2017, I was moving to the SJC, and that's just when the training program hit. So just so you know, the courts, a lot of them, at least in the liberal states or the blue states or purple states, are captured totally, and all the court personnel have been trained in this and taught this. It came in on the end of, just attached itself to DEI, diversity, equity, inclusion. So then, don't forget the rainbow people. And we were already all set. Massachusetts was fine, but it is taken over. And there's bills coming up to try to get sex ed into the state, because at the moment the state is the local communities do their own sex ed. But they're trying to pass a Healthy Youth Act. Right, which is not at all that. And I'll give the microphone back to you in 1 minute, but I just also wanted to say I was a law professor. I am a law professor, taught for years, and I was teaching feminist legal theory. Oh yeah. And I told the class, all women, that this is feminist legal theory, it's not gender theory. If you want gender theory, I teach that with Bob Ward. We teach race, women's rights, gender identity. That's a different class. This is feminist legal theory. We're going to talk about the history and feminist legal theory. Can I say that anymore? Get out of the class if that's not your thing. But they stayed. And they had, apparently there's a thing out there for checking your law professor to see if it's on the internet somewhere from Oxford, like looking for language so you can identify turf-prone professors. So, I had one student was really trying to get me to say trans women are women, and I wouldn't say it, so fine. So then the students are doing presentations, and this particular group was doing silencing of women, which we had done a whole section on, and branking, and the things they put on women's faces when they don't want them to talk. So lights are out, we're watching the presentation the 3 students are doing, and she's doing on silencing of women, and all of a sudden I see Dylan Mulvaney as an example of a silenced woman, because Dylan Mulvaney's Ulta makeup contract was being challenged. And I was sitting there and I said, you've got to be kidding me. You've got to do better than that. All right. The next week, I taught them Title IX, and they promptly used it against me. So I was sent to the principal's office at the law school and had to talk to the Dean of Diversity and the Title IX officer. And in the interim, before that, I'd been negotiating with the academic dean for a post-retirement position, but after I was cleared of this, we didn't need to resume discussions. So I knew I was retiring. I contacted Leah. I had her name through 2 different friends, and I knew that Wolf was where I wanted to be. And I'll tell you the reason, one of the reasons. The Wolf is against the ERA. People might think that's controversial. It's not. We have the ERA in Massachusetts since the early 70s, In 1979, there was a case where a boy was trying to play on the girls' team, and until the Scholastic Association said, no, we don't let boys on girls' teams. We let girls on boys' teams if there's no equivalent team, which is typically consistent with what we've all known to be the rules. But of course, the court I just came from wrote a decision in 1979 saying because of the Equal Rights Amendment, boys have to be allowed to play on the girls' team. So, you know, that's where Massachusetts is. He did. And he also had vetoed legislation which got him in a lot of trouble in the state because the trans lobby was attaching it to the abortion bill. So that bodily autonomy, right? So they were, and he vetoed that. He was overridden on that, but I'd love to talk to him now.
Yeah, model ethics rule for attorneys that the American Bar Association has and has been adopted by many states. So Rule 8.4 has to do with attorney misconduct, and they have proposed adding in a number of states essentially something that it's an enhanced version of what used to be a little note at the bottom, but essentially it says it will be misconduct to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, socioeconomic status, and conduct related to the practice of law. This paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with Rule 1.16, which, without getting into specifics, it also says this does not preclude legitimate advice or advocacy consistent with these rules. This has not been my experience with how it's been enforced. It's supposed to specifically not count advocacy. What they don't want is they don't want people yelling slurs at other people in the hallways of the court. Like that's the type of action thing, but we are increasingly seeing states adopt this and interpret it in the worst possible ways against basically dissenting opinions on a variety of things, but especially on this stuff. And if you ask during debates in states, my state, Wisconsin, is currently, they have just passed the subcommittee that was trying to figure out whether they were going to propose adopting it. It just passed that as a big yes, so they're probably going to be adopting it. And no one on the committee, which includes former Supreme Court justices of our state too, were able to answer the question, what behavior is not being captured by the current version of attorney misconduct that you are looking to stop from happening? Because if you're not trying to stop social media, if you're not trying to stop, other types of advocacy, what is it? And people cannot say. They simply talk about, well, nowadays it's so easy to get away with hate. And nowadays, like these are attorneys talking like this. Pennsylvania had also passed a version, their own version of this model bill, which went even further. And theirs actually said, they actually said in the practice of law, so it's attorney misconduct to, by words or conduct, knowingly manifest bias or prejudice or engage in harassment or discrimination, as those terms are defined in applicable regulations. But it added two things. It added that the practice of law includes continuing legal education seminars, bench bar conferences, and bar association activities where legal education credits are offered. So, specifically, if you have the very people who are seeking to pass these ethics rules are also the ones who are influencing or personally implementing the enforcement of it, they are the ones who think it is considered bias and harassment to go out there and have a CLE saying, you have a right not to do this, or it's considered sex discrimination to be able to do this. So some lawyers sued the state of Pennsylvania and it appealed, and we did an amicus brief. It was Greenberg v. Lahaki, and we actually thought that we had a really good chance, and we were excited to probably win that one, even if we weren't as successful against the model rule itself, but we're not successful in that one. And so they're really attacking lawyers' ability to be able to.
And that is one thing I will say for our court is that the model rule, of course, filtered through, but it hasn't been adopted. Our court didn't put it through. I think there's some sensitivity to that. There might be another point of view here, but one of the problems is something everybody said here, is that there's always a family member. So you're dealing with all these judges and staff who've been trained by the DEI and the gay and lesbian, the LGBT group, whatever, which one, I've heard what it is. They've been trained to be nice. We're gonna be nice. We're gonna respect pronouns. And they'll bend over backwards on pronouns. I think they're aiming at pronouns with that, right? No misgendering.
Oh, they don't like anything I say.
But no requirements yet in Massachusetts for legal education or concerns about that. So, but you know, that's for the moment. People change, courts change. Who knows?
There was a Harvard law professor, Alejandra something, who successfully led a campaign to get Wolf deplatformed from Give Butter, and was social media stalking me and another attorney who had done some work for Wolf, and literally said, this is a Harvard law professor, said, if either of you were barred in New York, I would file an 8.4 complaint because we dead named Amy Stevens in a brief. In a brief, it was in the Brandt versus Rutledge, it was challenging, or it was in support of the SAFE Act, which was banning child transitioning in Arkansas, so that was the case.
One thing that I've been thinking about a lot, because when this all started and I was teaching the feminist legal theory class, I watched a seminar, it was Zoom and it was COVID or whatever, of a con law professor from BU, and he was talking about Dobbs, and I asked him, with Dobbs and where the gender law is headed, do you see women ending up back under coverture? And he said yes. And you should talk to my wife. She teaches feminist legal theory too. So I made an appointment and went to talk to her, and she basically just told me, you know, this is the way it is, and this is, you know, I was out of step because even Catherine McKinnon agreed now. So I thought, wow, you know, there's nowhere to go. There's nowhere to go with this. And then I realized we don't have any sex-based rights anyway. We never did. We might have thought we did, but we really didn't. So we're really going to have to start from scratch, I think.
So is it okay, like the foot is on our necks, but the heels is okay?
Nice one. Yeah, that's it's really tough what's put in place here too. You know, the specific things that they try to do. I'm on the DEI committee of my state bar, and I keep getting lost off of the list for the media things. Yeah, they tried to, the president of our state bar at the time was really cool. She's not the president anymore, but they only get one term. But she knew exactly who I was and let me on when I applied to. They didn't say, hey, if you want to be on. I just heard that they were forming a committee, and I emailed and I said, I'd like to be on your committee, please. And touted my great qualifications. Anyway. So I got on it, and apparently she went to the Board of Governors meeting and said, okay, here's my list of people who are going to be on this DEI committee, and one of them recognized my name and took exception to it and tried to call a vote on whether I could be on the committee. And the president said, this is not subject to a vote. You don't get to vote. I'm letting you know that this committee exists and here's who's on it. And he brought it back up at the following meeting. I know this because she called me and gave me a heads up that this guy was also on the committee and was probably going to cause problems for me. He was a managing attorney at a legal aid firm in Wisconsin that has multiple locations and does a great work. I worked for them for 2 summers when I was in law school. They're amazing. He is not amazing. But they also, he really didn't want me on the committee. He felt like he said that he felt this adult human male felt unsafe on Zoom calls with me. I don't even say anything interesting on there. I just ask questions and,
I mean, laugh? I mean, what the?
No. Oh, no.
Oh.
There's also been, Wisconsin is another story. There's a lot of heated stuff related to the practice of law that have happened where people take I mean, remember this is the DEI committee, so we're talking about the TQ stuff, but there's a lot of really heated stuff related to diversity and inclusion and stuff in general. During the 2020, like Black Lives Matter protests and stuff, there was an attorney who like spit on some kid protesters and stuff. And so this was in this sort of political environment in the state in which I was seen as like in that vein, basically. Like I was one of those kinds of attorneys, like who, because I work for
Well, and then that's the automatic thing that happens, is if you have an opinion about women should have some rights, then you are automatically pushed over into the conservative camp for some reason. It's just like, so.
very much so.
Yeah.
That's it's absolutely crazy. But that's where we're at with some of those things, and it's not just there. So that there's ethics rules and there's ethics opinions and there's things like that. I'm sure you didn't do this, but there's a lot of judges who are telling people who are litigating in the cases that we work on that they can't use male pronouns to refer to men, can't call them boys, can't call them, and these are in cases where the entire litigation is about sex.
Right, and we had a probate court and family judge named John Smoot, who you can look up, he's on LinkedIn. He retired early, as I did, but not for the same reasons, but he retired because he didn't feel he could do his job anymore as a probate and court family judge if he had to bring in all these transgender issues in the probate and family court. So you cannot misgender somebody in some courts. You cannot properly sex them in some courts.
And that applies to just regular cases where there's two people who are, but it also applies to cases where the issue, the controversy going on. So my favorite one was in the Connecticut Sewell versus the Sewell case where the girls in high school and the track runners, where the judge had said that the attorneys couldn't call them boys, couldn't call them males, couldn't call them biological males, and they said because it makes it sound like this case is not about boys who just decided to, and I was like, this is exactly what it's about.
This is what is really concerning to me, is that in court cases like this, the judges are operating from the assumption that this has already been proven somewhere.
Right.
And no, there has been, as far as I know, no scientific hearing in court, which for any other kind of new evidence you would have. You have to pass some kind of threshold showing reliability and truth and accuracy and methodology to establish that this thing called gender identity exists. But it didn't come in that way. It came in sideways through training and through, I've got a family member, my, so-and-so's kid.
And it's the law clerks. They're all the law students at the law schools, and then they graduate, and then they're the law clerks.
Back in the back.
If you're part of the court case, if you're a defendant or a plaintiff, and you have to go in and swear to tell the truth, how could they legally force me to call a man
That's what
a
I
woman?
always say.
I mean, isn't that a First Amendment right? And I mean,
You're forcing them to commit perjury.
right. And then the recent case in Portland where the bartender was just sentenced to, I think, community service for calling a man who tried to get into the bathroom. She asked him to leave, and he brought charges, and she was found guilty and given 50 hours of community service for misgendering. So, I mean, does this eventually have to be a case taken to the Supreme Court?
Yes.
Yes.
Do we need a test subject?
Yes.
Yes. Is that your question?
Free speech.
Yeah. So Chandler versus CDCR is the litigation that we filed. That Wolf has actually, is counsel in the case. And from the very beginning, knowing what we've experienced and seen happening it's more often than not, people are either being censored by judges or self-censoring so that they're not viewed as controversial. And from the beginning, we've been looking at it as we're going to need to. California is a state that's adopted 8.4. And so we're looking at it as absolutely it's going to need to be decided.
Right. One answer to your question might come from the First Circuit, which is in Massachusetts. There's a school called Middleborough. It's a junior high I'm sorry, no, it's a middle school, so we're talking 5th, 6th, 7th, 8th grade, and there's a boy who had a t-shirt on that said there are only 2 genders. And so he was disciplined or sent home or whatever. Now there's a federal case out of it. And it went to the trial court for a motion to dismiss. And the trial judge there said, you know, yeah, you can't wear that t-shirt or the policy's fine. So now it's on appeal with the First Circuit Court of Appeals. I listened to the oral argument, and all I could hear between the lines is, oh my God, we've got to decide this. Oh my God, what are we going to do? I mean, that's my interpretation of listening to them ask legal questions. But I know that's what, you know, a lot of them might be thinking. Like, they just don't know what to do.
The issue is really people who have been through male puberty, so could you call them that? People
Oh,
who-
they've offered many alternatives we can use.
I'm sorry.
We're allowed to say, so what's one of the ones? Connecticut, they said you can call them girls who were assigned male at birth.
Oh, boy.
That was one of the ones that was okay.
It's not honestly just male puberty. I want everybody to understand. Literally, a 4-day-old embryo that's male has a faster metabolism already than a female embryo. It is literally from like minute 1. We are different. And they have advantages that we will never have. So it's really, don't let them do this about puberty. That's not it. It's the moment of fertilization on.
So going back earlier to postmodernism, I think postmodernism is a devil. And I'm I study philosophy in college, and so I'm all about like learning arguments, but postmodernism is trash.
Yeah.
It destroys objective reality. And my understanding of the legal system, law, it's based on logic. Logical reasoning is the framework. Objective truth is something that you're looking for. We have it grounded in what we can see and what the evidence shows. And so it seems like it's like I see from this whole conversation so far, it's like, what has postmodernism done to feminism? What has it done to the medical industry? And what is it doing to the law?
Right.
Because now we can't even have legal reasoning.
Well, you know, actually, this is just my opinion from what I know of lawyers I know. I actually think that one of the reasons that lawyers have been more susceptible to some of this than I would have expected is because we have an adversarial system. So we have objective facts, but we're used to arguing about what they are. And so there's like an expectation of like, I'm gonna be making the argument I need to make and stuff. So there's certain things that I think, just where I was like, why is everyone I know like,
But what about even consent? Like, think about things like consent. If it's objective truth and my truth and your truth, then nobody can say, like, if we're not applying these standards,
Yeah, it
it's all
destroys it.
apart.
It destroys it. It destroys it.
but that's in the sense of the court has spoken in those cases and has decided what the truth is, and the truth is that these are girls that were assigned male at birth, according to. So this is like, you get punished, and they actually had, in the lawyers in those cases, they asked the judge to recuse himself, and he refused, and then they appealed that and got just a denial from the appeals court on that without even commenting on it. And so those same lawyers who have litigated numerous other cases on gender identity, I have not known them to have argued on this point since this happened. And I think they have made a tactical choice to pick their battles, and they've approached it in a different way linguistically with trying to kind of be more proactive and saying it different ways. And that's one of the themes I wanted to say, is that we're always trying to do the best with the information we have and the tools we have. There's gonna be a time I might have to walk into a courtroom and say some stuff I don't want to say, or be held in contempt, and which means that I don't get to file the brief.
Well, and that's why I think picking your case, picking your battle has got to be really important in this, because you could, if you bump into the jurisdiction where they've adopted the model rule 8.4 from the American Bar Association, then you're going to have a hard road. But if you can get to a state with a case that doesn't have that rule, then at least you might be allowed to use correct sexing.
But also, unfortunately, some of the worst crimes against women are happening in the same states where they have that happening. So that's what we see with California. One circuit that I'm aware of has weighed in on this at all. and has done so in a positive way, which is in the Fifth Circuit, U.S. v. Varner, where they explicitly declined to follow the preferred pronouns, and they said that litigants should not be required, court personnel should not be required. They said it brings into question the neutrality of the judiciary. It looks bad. They attached to their decision an exhibit of like jur, jim, the different non-binary pronouns and stuff to say
What the
like
fuck?
well look what you're asking us to do. Really, this is not just a matter of you know just it was a very well written decision.
Yeah.
What
That-
case was
that's
that?
great.
What case was that?
U.S. v. Varner, V-A-R-N-E-R.
And I don't know if you remember Bostock, of course, right? When you read that case,
Fifth
Bostock.
Circuit.
Yeah,
Oh, Fifth Circuit.
yeah, but Bostock versus United States or whatever, Clayton County, was the guy who wanted to wear women's clothes in the funeral home. And Gorsuch's language in that, when I read that, I said, he didn't come up with that. That's a law clerk. You know, that law clerk put in all that gender language.
Oh,
I
and
mean,
the
that's
opening
what
line?
Yeah,
The one that's like, this is gonna make history, let me write.
right.
Some great
So the
prose.
law clerks are coming in already indoctrinated. I saw them in law school already indoctrinated from college. You couldn't even get the female students who agreed that women are women only to speak up because they're trained not to.
Yeah.
You two figured it out.
So if the law is traditionally seen as sort of the last resort,
Yeah.
right? So if the law is captured, I mean, what's next? I sort of feel like that this is gonna have to go the way the suffragettes went. Like we're gonna have to fill the jails.
Yes, we are.
If
Yeah.
we go to jail, guess who pays attention? The men who care about us.
Jail.
They don't care until it affects women they love.
Please do it.
Sharon always says, one of my favorite Sharon sayings, Wolf ED, is that we use all the tools in the toolbox.
Yeah.
And
What?
we use all the tools in the toolbox, and so.
All
of them. The legal system, such as it is, which is really a bunch of different components that could include criminal justice, civil justice, it's constitutional law, it's state law,
Federal,
law.
state.
Yeah, all of the above. It coexists with legislation, regulation, the administrative state beyond that, school districts, private parties, you know, and all of that. And so, yeah, and then there's direct action, there's consciousness, raising, media, all that stuff, and it's all interacts. And so that's what my dream is like strengthening this side of it, because we need the legal side to support all of this. You know, it's very reactive. We want things to happen that are good. We don't want things to happen that are bad, and then we have to react to it and fix it. And people are already harmed, and we can't, toast can never be bread again. So it's better to just not make the toast, like if possible.
Maybe you could say that in the court case. Toast can never be bread.
I like that.
I have been told.
Toast the sign of birth.
And all these things, but there's probably a lot of attorneys who agree with us. I know some, but they're afraid to speak up. I know some that are kind of in prominent positions, but they're just afraid to speak up. So how do we get them to do it? But they do have a lot to lose. It's not a joke.
It is-
We're here to try and make it safer.
And, I mean, that's a very good question. And I think somebody really famous needs to come and help.
Yeah.
I'm considering going to law school in order to be another,
I think the point is go get the degree. Just get the degree and don't worry about what they're doing in the school. Just get the degree, pass the bar, and get into practice. Yep.
Texas.
I think the point is go get the degree. Just get the degree and don't worry about what they're doing in the school. Just get the degree, pass the bar, and get into practice. Yep.
But I was curious if there was any hope of the anti-abortion laws and the IVF, they dispose of fertilized embryos. Is there any hope of lawsuits coming up of the obvious contradiction in this?
The Alabama case, you mean?
Well, I mean, I guess just philosophically, it's clearly like they're both fertilized
just go back to what Sharon had said in the beginning, or was it you, Sharon, or was it somebody else who said, look, just admit when the sperm fertilizes the egg, we've got potential life. Mary Lou said it, right. And so let's admit it and still say it's your body and you do not have to be forced to carry another life or be a life support system for it. So yeah, okay, embryos are one thing we've decided already, but.
It brings up a couple good points though, because I think it's really important to click through. I have been, one of the things that led to me being piqued in general was noticing the difference between reading an article about something and clicking through to what they were talking about and finding out, man, there's they just made it all up.
Right.
And how often that kind of thing would happen. And so I really do, especially when there's something really, really high emotion, click through and read it. And one of those things is with the Alabama law in particular, the only thing that changed, and this was under Alabama law, so it doesn't extend to other places, is that there is a statute in Alabama that allows parents to sue for wrongful death of the death of if a woman's pregnant and some negligence leads to it. So it creates parity there. So it says it doesn't, and so it creates a right of action just for the parents of the embryo, and it leads to that thing. So yes, can it be used for other things? Can it be expanded? Can the reasoning and the decision be used in other ways, good and bad? Probably bad in this instance. Yes, but the way it's been getting reported on is almost like there's been some Supreme Court decision handed down or something like this, when really it just said, hey, yeah, this state law also applies to this really narrow group of people.
And I think also on that point, it's the law is quite capable of holding two ideas at the same time. One being that the embryo that's an IVF is one way, and the right to abortion is a different thing. In that, even in Massachusetts, I have been on a case where I had to write it, and a pregnant woman was killed, and she was very close to term, where we have a viability issue. So the baby was viable. It was a baby at that point. Whatever it was viable. So there are 2 counts of murder. But we're very, very strongly protecting women's rights. Potential life. Mary Lou said it, right. And so let's admit it and still say it's your body and you do not have to be forced to carry another life or be a life support system for it. So yeah, okay, embryos are one thing we've decided already. But
It brings up a couple good points though, because I think it's really important to click through. I have been, one of the things that led to me being piqued in general was noticing the difference between reading an article about something and clicking through to what they were talking about and finding out, man, they just made it all up. And how often that kind of thing would happen. And so I really do, especially when there's something really, really high emotion, click through and read it. And one of those things is with the Alabama law in particular, the only thing that changed, and this was under Alabama law, so it doesn't extend to other places, is that there is a statute in Alabama that allows parents to sue for wrongful death of the death of if a woman's pregnant and some negligence leads to it. So it creates parity there. So it says it doesn't, and so it creates a right of action just for the parents of the embryo, and it leads to that thing. So yes, can it be used for other things? Can it be expanded? Can the reasoning and the decision be used in other ways, good and bad? Probably bad in this instance. Yes, but the way it's been getting reported on is almost like there's been some Supreme Court decision handed down or something like this, when really it just said, hey, yeah, this state law also applies to this really narrow group of people. And
I think also on that point, it's the law is quite capable of holding two ideas at the same time. One being that the embryo that's an IVF is one way, and the right to abortion is a different thing. In that, even in Massachusetts, I have been on a case where I had to write it, and a pregnant woman was killed, and she was very close to term, where we have a viability issue. So the baby was viable. It was a baby at that point. whatever it was viable. So there are 2 counts of murder. But we're very, very strongly protecting women's rights on abortion. And there I went with that we again. They.
The royal we. That's such a good point. This is all the other thing that I was thinking of when you talked about this is that is why it is so important to have feminist viewpoint and feminist analysis in this legal fight, is because these things are not, this is not, oh, we've got commercial sexual exploitation and reproductive rights and gender abolition and all these are all the same beast, and these are just different manifestations, and we're the only ones in there saying that, and we cannot rely on our partnerships with other groups who are conservative, more conservative, have immense value, and a lot of them do really good work. There's great kind of synergy, things that you can say that, but we can't, and we can do this, and working together on things. But there's things that if we don't say it, no one's gonna say it, and so some of those it's really important to keep that in mind, that things like keeping the rights of lesbians protected in the fight against gender ideology, so that doesn't get wrestled back. And one of the cases we did an amicus brief for was in Tingley versus Ferguson. There was a Washington state law that banned it was conversion therapy for minors. It only applied to licensed therapists, and it was already considered unprofessional conduct for therapists in Washington to do forcible conversion therapy for sexual orientation. So it literally was a law that just made affirmation-only therapy the only, everything else was considered conversion therapy. So, going in and being able to say, here's why feminists don't support this law, and also talking about the ways in which this is medicalized conversion therapy itself. No one else said that, and so it's really important that this work continues and that we're able to still weigh in that way, because otherwise it's just, we don't want to have the same outcomes. We've got, the feminist, we're definitely the little guy on this stuff, but so there's really good work being done by partners and stuff, but they have their own priorities and their own values that they do it based on, and we have to go out there and put ours in writing too, and do that, and I think that's how we're gonna,
And how can people support your work?
I don't have any yet.
Sorry.
So, yes, so 2 immediate things come to mind. One, women'sliberationfront.org is where you can donate money, and you can sign up to be a supporter. You can become a sister in action and all of that, and just get involved. And also, if you want to volunteer, especially if you, but not just lawyers, but even for there's all kinds of volunteers needed, but for my own personal purposes of getting legal work done, definitely we're really looking to expand that, and we've had very little capacity to do anything but the thing that's right in front of us going forward, and we're looking to really be able to take advantage of that. So anyone who is interested in getting involved in anything, reach out. But I'm legal director at women'sliberationfront.org, and so if anyone wants to reach out, and I can try and find some work.
Are you looking for any specific kind of cases too, or are you if we hear stuff in our own life about
Yeah,
what kind would you be looking for?
I'm looking for information. I know what I hear. If I had a whole, if we had a whole ACLU full of turf lawyers, then I would be able to lay out some this kind of case and this kind of thing. But I've got you.
Just the national branch of the ACLU, not the state branch. It's just the national. They have 800 lawyers.
Oh, wow.
Okay, we have one.
Right.
She's really good.
I'm really tired.
She's mom. She's a child. There's a lot going on.
The law is supposed to be objective,
Yeah.
right?
Objective.
And that's what I was
fact-based,
saying
evidence.
about the medical community. It's like,
Oh,
wait a minute. How did this happen in medicine and science?
But they don't have to police themselves. That's something that was pointed out. Like, so the medical industry, like, they police themselves, and the only thing we have is malpractice redress.
Right.
So how do you guys police yourself with your bar association?
Right, and the bar associations, at least where I come from, are very much into this, because it's
They're
the
a big bummer.
next new thing, you know? It's, everybody's into it.
I would add this. As I was thinking about it, I was with Healthy Youth Act, and where they're putting gender ideology, tying it as a requirement to sex education. Now, this is already happening in a lot of schools across the nation, but one thing I was thinking about it, when we're introducing this to kids so early, what we're doing is introducing this. There's no objective truth.
Right.
So they're learning at a very early age that instead of evidence-based, everybody's truth is everybody's truth, and that seems like it's going to screw people up. And they're susceptible to very sophistical arguments.
Yes, and they're also learning that their sense of self isn't stable. And it seems one way out might be financially, if there are enough someday malpractice suits and they get a big hit. And I think I read that an insurance company was backing off of insuring some of the doctors who do this. When that starts to happen, then maybe there'll be some changes there. But you have to find the money and, get that exposed.
Another thing to expose is the amount of profits that the healthcare industry makes from this.
Yes.
They're not talking about what's causing it, they're talking about drugs and surgery.
And
Profits.
it's for the life of,
Lifetime
yes,
patients.
their lifetime attached to the medical system.
That's our whole medical system though, unfortunately. It all treats symptoms. We don't treat root causes
Right.
here. So.
Well, this is depressing. I'm just kidding, it's not.
No, I will tell you, there's so many women who've been doing this for so long and stuff, but I still feel sometimes like I'm been around forever, even though I've only been around since 2020. Doing stuff, I feel like this old, whatever. But even in that time, things have changed so much, really. Like really. In terms of being able to be open about things, I think there's been a concerted push to really normalize the diversity of thought. I have seen that, and I have seen some positive movement in that direction, and I think it's come from people being more unapologetic on just like, nope, that's not what I believe, and sort of quietly insisting on that. And I do think that's one thing I think is swinging in a positive direction. In general, I hope that continued, also includes in court, because I really want the judge in Chandler to like me.
Sure they do.
Maybe. She said my plaintiffs were cisgender.
Until I listened to Professor Vierling yesterday afternoon, I didn't have words or categorization process to explain what I was feeling when I was handling some of the cases we were doing, and I was dissenting, because I knew it's just not right what we're doing, but I didn't know we were creating a second and third patriarchies. And if I wish I had known that language, then I could have gotten it into a dissent.
And that is why I would really like to learn more about this training that you all are getting as judges and offer some alternative training.
That would be good.
That'd be good.
Because I think that's where they're getting us. They're getting these low-income kids with free health care, and it's becoming gender-affirming care. And they're getting these legal aid clinics, but you can't get one to sue if you're being harmed by gender in some way, whether it's discrimination in a job or anything.
It's like a pregnancy crisis
The
center for law.
NGO industrial complex
Ouch.
is completely captured. So people without resources have no way of fighting back at all against any of this. Whether it's legal aid, whether it's free health clinics, whether it's anything, and then schools and all of that. And one of the things is that businesses really are taking a lot of this free training and free resources and free this and that, And it's all telling them the same thing, which is that this is your obligation to your employees, this is your obligation to your customers. They're not getting anything, even though there's another version of it, right? Like, and so I would really like also, if anyone's interested in volunteering to do some of that, make some of these materials to provide them, either training materials or physical things to give to them, especially the ones who are looking for it. There's a lot of businesses, schools, and like institutions that don't need to be convinced, they just need to be empowered. And so I think that's really something that I think if we start looking for the people who are looking for help and helping them in that way, it could really get some impact out of that.
Let's write a grant for that.
So just for example, I have gone to testify for Title IX in front of Congress, and I'm going on Tuesday for a Senate roundtable. No Democratic senators are coming to this roundtable. So I'm asking all of you as a call to action to reach out to your representatives who are in DC, because and the same thing happened, the Title IX hearing that I testified at, not one Democratic representative supported women. And it was, I wanted to cry.
I really think the feminist messaging is important.
Yeah.
I think that, and not just for Democrats, I think for any of them, I think needing to hear the reason why, needing to hear that this is, sex discrimination. Feminists oppose this. This is discrimination on the basis of sexual orientation against, same-sex attracted individuals.
I find that one helps
and
a
all
lot. That argument is
very
good.
much so.
I like
and,
that one.
and people don't know what's going on, and so it's not even just saying it. You're actually able to like show your work.
Well,
I
they're
think that's
trying to
really
throw lesbians into the saying that every lesbian is against this.
Right.
Every time I say, no, that's not true.
right.
Right.
So I think saying that, really just saying, actually, we just don't feel that way, and I think that's the important thing about. I really do think that this issue is nonpartisan in a lot of ways. I think that there's the politicians seem to be very lockstep, but the voters, just the regular people, I think I mostly encounter people who are like, I really kind of agree, but you're not supposed to say it. My own family agrees with almost everything, but they think that it's mean to do it the way we do it.
Right.
Focusing on misgendering and things like that. And so I think there's such a capture that it's hard to break through. So simply saying, like, why do you feel that way? Like, this is discrimination.
So I'm just saying, if people can reach out to their representatives, I will be there Tuesday. I will be at the Senate on Tuesday for a roundtable with senators from 1, or I guess it starts at 2, like 2 to 4 p.m. and it'll probably go till 5. And
What committee or what senator is sponsoring it?
Yeah.
well, don't even ask, because you don't want to know who's sponsoring.
I don't care.
It's Tuberville.
Oh,
Tommy. But who cares? This is where I'm saying, I don't care who's sponsoring anything. This is about getting our rights back. So I think that's right, black and purple have to fight together to get these rights back.
That's right.
Absolutely, that's very well said.
Yay, Kim. I don't know.
She's so good. She's so great.
The last one was, and not one female representative on the left supported me, or any of us. They sat with their phones to the left when we spoke.
He turned their backs on us.
Yeah.
Yeah.
Okay, stand up and take a bow.
Give it up to the legal team here. Excellent job. Excellent job. And Lauren will get you more than one attorney. Don't worry, you won't be all by yourself.